Welcome back to another episode of the Divorce Lawyers podcast, your go-to source for all things family and divorce law in Ontario. I'm Deepa Taylor. Today we're diving into a topic that many people find overwhelming: understanding bankruptcy in the context of divorce. Bankruptcy on its own is a daunting subject. Add divorce into the mix, and it can feel like you're navigating a maze with no clear exit. But don't worry. By the end of this episode, you'll have a clearer understanding of how bankruptcy might intersect with your divorce proceedings and what you can do to protect your interests. Let's break this down into manageable parts. We'll start by understanding the basics of bankruptcy and consumer proposals, then move into how these can impact divorce proceedings, including equalization, support payments, and the roles of various parties involved. We'll also touch on some practical tips and strategies to consider if you or your spouse are facing bankruptcy during a divorce. To start, let's clarify what bankruptcy and consumer proposals are. Both are governed by the Bankruptcy and Insolvency Act, BIA, in Canada, and they offer different solutions for individuals overwhelmed by debt. Bankruptcy is often viewed as a last resort. When someone files for bankruptcy, they're essentially declaring that they cannot pay their debts. This results in an automatic stay of proceedings, which halts all legal actions, garnishments, and judgments against the individual. In bankruptcy, non-exempt assets are surrendered to a licensed insolvency trustee who sells them to pay off creditors. On the other hand, a consumer proposal is a formal offer to creditors to settle debts for less than what is owed. The individual retains their assets but must make regular payments, typically over a period of up to 5 years. This option is often preferred as it can be less disruptive and less stigmatizing than bankruptcy. Now that we've covered the basics, let's explore how bankruptcy can affect a divorce. When one or both spouses file for bankruptcy during a divorce, several key areas are impacted, including equalization payments, spousal and child support, and the division of assets. Equalization is the process of dividing the net family property between spouses. However, if a spouse files for bankruptcy, their ability to pay equalization may be compromised. In bankruptcy, equalization claims are treated as unsecured debts, which means they don't have priority over other creditors. This can significantly reduce the amount the non-bankrupt spouse receives. Spousal and child support, on the other hand, are considered priority debts. This means that they survive bankruptcy and must still be paid by the bankrupt spouse. In fact, the reduction of other debt obligations might actually improve the bankrupt spouse's ability to make these support payments. When it comes to the division of assets, non-exempt assets of the bankrupt spouse are surrendered to the trustee. This includes any equity in the matrimonial home, investments, or other valuable property. If the matrimonial home has significant equity, this can be particularly challenging, as the trustee may force a sale of the home to pay creditors. Understanding the roles of various parties in a bankruptcy case during divorce is crucial. The licensed insolvency trustee plays a central role in the bankruptcy process. They act as an officer of the court and a fiduciary for the creditors. The trustee's duties include assessing the bankrupt's financial situation, realizing non-exempt assets, and distributing the proceeds to creditors. They also oversee the discharge process, which we'll discuss in more detail shortly. Creditors are categorized as secured, preferred, or unsecured. Secured creditors, such as mortgage lenders, have the first claim on assets. Preferred creditors, including those owed spousal or child support, are next in line. Unsecured creditors, who may receive little to nothing, come last if the bankrupt's estate is insufficient. The non-bankrupt spouse may find themselves in a difficult position, particularly if they're owed equalization or support payments. They may also face scrutiny from the trustee if any assets were transferred to them prior to the bankruptcy, as this could be viewed as a fraudulent conveyance. Timing is critical in bankruptcy, especially when it intersects with divorce. Whether the bankruptcy occurs before or after separation can significantly impact the proceedings. If bankruptcy occurs before separation, both spouses may already be aware of the financial difficulties, which can lead to more collaborative solutions. However, if one spouse transfers assets to the other in anticipation of bankruptcy, this can be challenged by the trustee as a fraudulent conveyance. When bankruptcy happens after separation, the non-bankrupt spouse might be blindsided, particularly if they were relying on equalization payments or shared assets. This can lead to complex legal battles, especially if the matrimonial home or other significant assets are involved. Fraudulent conveyances are a common issue that arises in divorce-related bankruptcies. This occurs when the bankrupt spouse transfers assets to the non-bankrupt spouse in an attempt to shield them from creditors. These transfers can be set aside by the trustee if they happen within a certain time frame before the bankruptcy filing. If you find yourself in a situation where bankruptcy is a possibility during your divorce, there are some strategies and tips to keep in mind. First, ensure that any separation agreement clearly delineates how equalization payments and support obligations will be handled, particularly in the event of a bankruptcy. You may want to include provisions that protect support payments, even if equalization is compromised. In some cases, it may be possible to assign equalization claims to a trustee in bankruptcy. This can allow the non-bankrupt spouse to still receive some payment, even if it's not the full amount originally agreed upon. Finally, seek professional advice early. If you suspect that bankruptcy might be on the horizon for you or your spouse, consult with a family lawyer and a bankruptcy professional as early as possible. You can consult one of our family lawyers by visiting DivorceLawyers.ca. We can help you navigate the complex intersection of these two areas of law and protect your interests. Navigating the intersection of bankruptcy and divorce is undoubtedly complex, but understanding the basics and knowing what to expect can make the process more manageable. Remember, the goal of bankruptcy law is to provide a fresh start for those overwhelmed by debt, while also balancing the interests of creditors. When combined with divorce, the stakes are higher, but with the right guidance, you can work toward a resolution that protects your financial future. If you're facing this challenging situation, reach out to a qualified family lawyer who can help you understand your rights and options. For personalized guidance, please consult one of our family lawyers by visiting DivorceLawyers.ca. Thank you for joining me today on the Divorce Lawyers podcast. If you found this episode helpful, please share it with others who might benefit, and don't forget to subscribe for more insights into family and divorce law in Ontario. Until next time, take care.